Good afternoon or good morning, depending on where you are. Thank you so much for joining us for our webinar, Preparing for Immigration Investigations and Enforcement Actions. My name is Igor Babachenko, and I am a partner at McGuireWoods in the Richmond office. Before returning to McGuireWoods last month, I spent 3 years with a global meat packing company where I handled all compliance issues related to labor and employment and immigration. So this issue is something that I had to deal with through trial by fire, and it's something that is very important. With me, I've got Mindy Souter. She is a partner in our Dallas office. And Mindy boasts a distinguished career as a trial attorney, both at the state level as a county prosecutor and at the federal level as an assistant U.S. attorney. So she's seen the enforcement side, both on the side of the government and now representing her clients. And she's got extensive experience representing clients in immigration audits and enforcement actions, including navigating complex legal processes and ensuring compliance with immigration laws. Also with us presenting is Katie Barnes, and Katie is an associate in our Charlotte office. And Katie has extensive experience advising clients on work authorization requirements, immigration law compliance, and helping clients walk through I-9 audits and other enforcement actions. So again, thank you very much for being here. Today, we're going to cover several topics related to immigration enforcement actions. We're going to give you an update on the current state of things. We're going to give you some tips on how to prepare for and how to respond to workplace enforcement actions. And we're going to discuss proactive immigration compliance, what you can do before the government comes knocking so you're well prepared if and when it does. So the current state of things, as you all will recall, during the last presidential campaign, President Trump made immigration enforcement a key aspect of his campaign. And he has followed through on that as president. Tom Homan, the House Associate Director of Enforcement and Removal Operations, said very early on that worksite enforcement operations are going to massively expand. And they have. During the Biden administration, there was not much going on in the field of workplace enforcement. I talked to an ICE agent friend of mine at the time who said that effectively that his hands were tied on any worksite enforcement actions. So that's been a complete sea change under the new administration. And you know, there's an old saying, show me where you put your money and I'll show you where your priorities are. And it's been clear that immigration enforcement is a big priority for this administration. House Resolution 1, or as it's known, the One Big Beautiful Bill Act, allocated $165 billion to the Department of Homeland Security. The Act included plans to hire more than 5,000 customs officers for Customs and Border Protection and more than 10,000 new U.S. immigration and customs enforcement agents. That's ICE. Along those same lines, the Department of Justice updated its criminal division enforcement priorities and expanded its whistleblower program to include reporting on corporate immigration and visa fraud violations. For its part, the FBI announced that it would allocate additional resources to investigate these offenses. So as you can see, this is a whole of government effort. We've got some great coordination between the various agencies to make this a continuing priority for the administration. Now, as you know, the government shutdown is now in effect. And ICE on its X page, I guess tweeted or tweeted, however you say it, that there is no change to U.S. immigration laws or border enforcement. And the no change was in all capital letters. Now, in past government shutdowns, ICE temporarily stopped serving notices of inspection for Form I-9 audits. We don't expect that to be the case during this government shutdown. ICE has estimated that approximately 19,626 employees out of its total 21,028 employees would continue to be retained during the shutdown. So based on the messaging that we're hearing, we are assuming that it is business as usual for worksite enforcement actions, including raids and I-9 notices of inspection during the shutdown. Now, in the past with shutdowns, there was a temporary shutdown of the E-Verify system. As of right now, and I did check at about 11 a.m. Eastern this morning, E-Verify is still operational. So for the employers who use E-Verify, you're going to want to keep doing so unless and until you see that the system, for some reason, is down. That doesn't change, even if the system is down, that doesn't change your obligation to complete the Form I-9 no later than 3 business days after the employee's first day of employment. If the E-Verify system does go down at any point during the government shutdown, once the E-Verify system is operating again, as in past shutdowns when this has happened, we advise employers to process the E-Verify inquiries who are subject to the shutdown freeze period as soon as E-Verify is operational again. The system may trigger a question requesting a reason why the E-Verify case is being run outside of the 3-day window. And if it's not inserted as an option, we would consider typing something like federal government shutdown under the other drop-down selection. But as far as worksite enforcement goes, right now the expectation is business as usual. So I want to go through some recent examples of worksite enforcement actions. And these are all things that have happened just within the last few months. I'm sure you've all seen a lot of these on the news as well. Just last month, there was a mass-scale workplace enforcement operation at a vehicle battery plant in Georgia, and that resulted in detention of approximately 475 individuals. And that was the largest, or among the largest, worksite enforcement actions in history. Also last month, there was an enforcement action at a food manufacturer in New York, which detained more than 50 individuals. And if you haven't followed that one on the news, it had a significant impact on that manufacturer's ability to continue operations. It effectively lost a significant portion of its workforce to the operation. In August of this year, there was a multi-state operation with search warrants executed in Nebraska, Minnesota, and Nevada that resulted in more than 100 arrests. In June, there was an enforcement operation at a meat packing plant in Nebraska, which detained more than 75 individuals. And I can tell you, at the time, I was working in-house for a meat packer that had a meat packing plant within a 10, 15-minute drive of where this enforcement action took place. So you can imagine the news of that spread very quickly to the company's workforce. And luckily, we had our internal folks prepared to address employees if and when such a situation arose, which just went to show that that preparation was integral in keeping things running smoothly while rumors were spreading like wildfire. June 2025, enforcement operation in Louisiana. This was targeted at a racetrack, and there was more than 80 individuals detained in that one. So right now, workplace enforcement operations are running hot, and we anticipate they're going to continue to run hot. So far this year, there's been more than 1,000 arrests, more than 1,200 subpoenas for business records, and millions of dollars in fines. And that's just through May 2025. We've also had thousands of notices of inspection for I-9 files at a rate we have not seen before. I spoke with a DHS agent a couple of months ago, and he told me that they're issuing notices of inspection at such a rapid pace that investigations are taking longer and longer to complete. But even if that's the case, there's no intention to slow down, and there's no intention to give companies more time to respond. So the investigations are taking longer, but your response deadlines are still there. The expectation is that 2026 is going to be even bigger than 2025 for workplace enforcement operations. Again, Tom Homan said recently when being interviewed about the raid in the Georgia vehicle battery plant, and he said, quote, "We are going to do more worksite enforcement operations. No one hires an illegal alien out of the goodness of their heart. They hire them because they can work them harder, pay them less, undercut the competition that hires U.S. citizen employees." So you can take his editorializing on the back end with a grain of salt, but his statement that we're going to continue, you should not take that with a grain of salt. I think that's going to be the case. So what we've seen so far is enforcement in waves. And what I'll call the first wave targeted unauthorized aliens with criminal records, unauthorized aliens that already had deportation orders on files, and unauthorized aliens that had been deported previously and re-entered the country illegally. And it's also targeted specific industries that have a sort of reputation for hiring unauthorized aliens. And these tend to be more low skill, lower pay industries such as agriculture and meatpacking, manufacturing, construction, service, and hospitality. But the scope is expanding. The direction from President Trump to the enforcement agencies is look everywhere. And so just because you may not be in one of these, we'll call them targeted industries, doesn't mean that you're not going to be subject to a worksite enforcement action or an I-9 audit. Again, this is a big priority for the administration, and it's going to continue to be a big priority for the administration as we roll from 2025 into 2026. So again, what are we seeing? And it's not just worksite visits. As I mentioned, there's been an increase in notices of inspection. These are issued to businesses, and the idea behind it is the more we send out, the more it's public that we are sending these out, the more audits we're conducting, the more employers worry that they're going to be audited, and that's going to create a, quote, culture of compliance among employers. There was a direction to ICE field officers to increase the I-9 audits per region. We don't have exact numbers because those numbers are not public. I've seen something along the lines of more than 5,000 notices of inspection issued, I think, either through the beginning of July, through the end of July. But what we are seeing based on the data we do have is that investigations are up 30% year over year. And also in January of this year, the civil monetary penalties for I-9 violations increased. So not only are you getting more audits now, the penalties for technical violations and other violations have increased as well. So there's more money at stake now also. So that brings us to the next slide and why we're here. Given the current environment, it is of paramount importance to prepare for and be able to respond to a workplace enforcement action. And I am, as Coach Vince Lombardi once said, failing to prepare is preparing to fail. And so it is with worksite enforcement actions. So we recommend developing a plan for a possible workplace visit, because when you've got a plan in place, you've got folks that are trained how to respond, you can make I'll be honest here, a difficult and potentially traumatic experience go about as smoothly as it can. So what should be included as part of your plan? Well, the first thing is you should designate a point of contact for interactions with government agents. Now, I know that at least some of you have been following the news and you've seen the stories about the confrontations with ICE agents, the recent shooting in Dallas, and all that is to say that ICE agents are currently operating in a very, very hot environment. And when you operate in that environment, there's a tendency natural perhaps to come into any situation, with a more aggressive posture. And so you want to designate a point of contact if and when ICE does visit, who is able to remain cool, calm, and collected, and be able to interact with government agents in an appropriate fashion. And it's going to be very important that your point of contact is trained on how to interact with and how to respond to a workplace visit. The next part of a plan is designating and marking private areas. My colleague Mindy is going to cover this in more detail here in a little bit, but it's going to be important to differentiate between private areas of a workplace and public areas of a workplace, because depending on what type of what type of document the government agents present, that's going to control what kind of access you are required to give them. And that's why another key point in a preparation plan is to make sure that your point of contact and your employees generally understand the difference between different enforcement mechanisms, the judicial warrant versus the administrative warrant. Again, a good preparation plan requires training employees to direct law enforcement agencies to the point of contact. You don't want somebody that hasn't been trained and prepared to interact with government agents taking lead on this. And that's why, again, it's important to have one or a couple point of contacts who are going to be the main go-between with the government agents. And finally, it is important to have legal counsel on speed dial. And I don't say that as just a way to drum up business for me and my colleagues, but I say that because it is important. To give you an example, I had a situation where government agents came on site at a client's property, and they came in with an aggressive posture, and the supervisor on duty didn't quite know how to react. The agents were sort of moving from place to place, and I didn't get called until about 45 minutes into this whole scenario. I was able to very quickly speak with the agent in charge and kind of de-escalate the situation, because quite frankly, the agent in charge now knew that counsel was involved and knew that if they took any missteps, that could cause some blowback on them. So that's why it's important to have legal counsel on speed dial and to contact legal counsel immediately if there's a workplace visit from government agents. And with that, I'm going to turn it over to my colleague, Mindy.
Thank you. Like Eeyore said, it is important to get your employees ready for any type of possible interaction that they might have with ICE. And as he just explained, one of the best things that you can do to prepare everybody is to let them know exactly what could happen when those agents show up. A point of contact is a must. That way that person has the ability to control the situation, interact with counsel, and make sure they're getting all of the information that's necessary to proceed in the right way. One of the first things that needs to be established in your organization is what is a public versus a private area. And we'll get into the different types of enforcement actions when ICE comes onto your property that can occur, the difference between a judicial warrant and an administrative warrant, and the reason why those are important. In terms of the public versus private space, it's important not only that you have certain designated areas that are private, but that you mark those private. So when an administrative warrant is brought in by an ICE agent, they can only enter into areas that are public. And so they can ask questions of employees, they can interact with people as long as they remain in public areas. The only way that those agents can enter into a private area is if they have a judicial warrant. It kind of gets murky in some situations on what areas are public versus private, especially in organizations like restaurants or retail stores. Construction sites are a little bit easier, manufacturers are a little bit easier because you typically have fenced off portions, and it's easy to distinguish between the private areas and the public areas. And so we really do recommend that for each business, you guys designate private areas and you make sure that you mark those clearly so that when agents show up, there's no question what areas they are allowed to go in based on the warrant they have and what areas they must stay in. Another thing that is really important to train your employees on is to not invite agents into their private spaces. We talk a lot with our different clients about their employees, and when they see agents, they get what we call uniform scare. They just freeze and they don't know what to do, and they just forget everything. And so working through and educating your employees about what could happen when ICE walks in is incredibly important. You guys should be having monthly meetings with your employees to update them on the new things that are happening in the immigration world, and to make sure that everybody is still current on what the rules are and what they should be doing if ICE walks into the business. One thing for sure to train employees on is if ICE agents do walk in, the first thing they should do is go straight to that point of contact. The point of contact will have all of the information necessary to take those next steps, but you don't want employees who aren't that point of contact to start answering questions. And also, it's important to tell them, don't take them back into the private areas where the employees only room is. There's a tendency to want to get them out of the public view and to try to quiet things down. But once you take ICE agents back into a private area, it can sometimes be difficult to get them out. And so understanding the public and the private areas, making sure that they're clearly marked, and also educating your employees on how to deal with each of those spaces is incredibly important. The next thing to talk through, not only with your point of contact designation, but also with employees, because in some instances, you may get employees that start to have a conversation, even though you've told them that they need to go to the point of contact, is to recognize the difference between a judicial warrant and an administrative warrant. When ICE officials show up on your business grounds, they are most likely going to have pieces of paper in their hand. One of the things that we tell everybody is, with your point of contact and also with other employees, train those employees to ask to take a picture of each one of those pieces of paper. We like to do that so that those can immediately be transmitted over to legal counsel, so we can start to understand what it is that those ICE agents have in hand and what they're looking for. A judicial warrant, like I said earlier, is going to be very different in the way it looks from an administrative warrant. And I'm going to show you some samples here in just a minute. The judicial warrant is signed by a judge, and it is something that you do have to comply with. But it is also something that your point of contact should contact counsel and should make sure that that is a valid warrant before they allow those agents to start walking through the different parts of the company. An administrative warrant does not have a signature by a judge. And as we discussed just a minute ago, it only allows ICE agents to interact in the public spaces of your business. An administrative warrant is usually a removal warrant, and it's going to have individuals that they are there to remove because they have reason to believe that they're here unlawfully. In terms of the administrative warrant, one of the things to make sure to talk through with your employees is, while they are not allowed back in the private space, those ICE agents can stand out in the public space and they can wait for those particular individuals that they're looking for. I think it's extremely important when you're educating your employees to talk to them about the fact that they cannot and should not ever encourage individuals who are named in these warrants to flee. One of the things that we do have great fear about in this administration is that there is an opportunity for them to file obstruction charges against people that they believe are prohibiting or getting in the way of them exercising these warrants. And so it is important to make sure that as you're training employees, you let them know that letting individuals know that they have been contacted and ICE is looking for them, that is okay to do. But having them give direction to those employees that they should scoot out the back door or get off the property to avoid that type of interaction is something that we think can be incredibly problematic and could lead to charges of its own. These next few slides show you the difference between a judicial and an administrative warrant. I actually think one of the best things that you can do for your point of contact is to print samples like this off and make sure that they have them handy so that they can use them to compare. On the left side, you see a copy of what is a judicial warrant, and it says very clearly at the top, it's the United States District Court, and it's got some markings on there that clearly make it known that it's from a judicial court and it's going to be signed by a judge. On the right, you see an administrative warrant. And if you look closely at these, You'll see on the left-hand side, right down in the middle, it says it's signed by a U.S. magistrate judge. That's the judicial warrant that gives them the ability to go into public and private spaces. And then if you look at the administrative warrant on the right side, you see that it is signed by an immigration officer. That is the type of paperwork that you would see when an individual walks in and doesn't have the right to go into the private spaces, but does have an administrative warrant for removal. So training individuals with those types of pieces of paper so that they can clearly see what type of warrant those immigration officers have is important, and make sure that they understand when they can, when they should, and when they have to let the immigration officers into the organization.
Thank you very much, Mindy. And as I was talking, I did just get notification from E-Verify that the website is now down. So if you go to the E-Verify website now, which is everify.gov, you'll see a big red notice at the top saying that due to the lapse in federal funding, the E-Verify website will not be actively managed. It now also currently says that transactions or E-Verify case reports submitted via this website might not be processed, and we will not be able to respond to inquiries until after appropriations are enacted. And while E-Verify is unavailable, employers cannot access their E-Verify accounts. So with E-Verify now being down and until it is back up and running again, our recommendation is to continue doing your Form I-9s within 3 business days of the employee's date of hire, and then running E-Verify cases for anyone for whom you were not able to do so during the shutdown as soon as the E-Verify website is operational again. So that's just a brief update on where we are right this second. As you can see, things are moving fairly quickly and tend to move fairly quickly in this world. So the next few slides sort of cover and reiterate the things that Mindy just talked about. You know, in your interactions with government agents, you want to have an employee who's got the confidence to you know, address the agents and lead them through the process in a calm and respectful manner. Again, they should engage the agents in a public area and not invite them into private areas, because without judicial warrant, as Mindy said, they cannot get into private areas. And again, if they come in, they should be referred to a designated point of contact, and legal counsel should be contacted. Again, as part of any preparedness plan, these are the steps you should follow in training your designated point of contact to respond to a government visit. And then ultimately, if you do get a worksite enforcement visit, you're going to want to, you know, take detailed notes of what you observed during the visit. What did agents do? What did they examine? What did they look at? With whom did they speak? What did they say? What documents did they deliver? And ultimately, you're going to want to provide all of that information to your legal counsel and be able to determine the next steps. The more information your legal counsel has about the worksite visit, the better your legal counsel is going to be able to respond and take the appropriate next action. So as far as best practices, again, we want to reiterate that ICE officials do not have an automatic right of access to employees or business records or non-public spaces. That is why it's important to know the difference between an administrative warrant and a judicial warrant, and to review whatever documents they present closely, and to contact legal counsel. And again, I started this section by telling you that failing to prepare is preparing to fail. But if you are well prepared and have a good plan in place that you can follow, the whole process will be a lot more painless than it would have been otherwise. With that, I'm going to turn it over to my colleague, Katie, to talk about some proactive measures.
Thanks, Igor. So we've talked a lot about workplace visits, worksite raids and such. And so I want to switch gears and talk about the Form I-9 inspections, also referred to as audits. I want to go through what happens during an audit and how to prepare for those. This slide may have been a good slide for the beginning. Sometimes these agency acronyms can feel a bit like alphabet soup. So I wanted to run through a few of them so that you know what you're working with when you see them. I think we're all familiar with ICE. DHS is the agency that houses ICE. People are most familiar with that. And then we also have underneath ICE the Homeland Security Investigations Unit. And HSI is really the primary agency that you'll see during these I-9 audits. Less frequently, you'll see the other two listed here, the Department of Justice Immigrant and Employee Rights Section, and the U.S. Department of Labor, who also have authority to ask you for Form I-9s. But when we go through the slides that come, I'm really talking about the process through HSI. And I don't want to forget about state inspections while we're talking about these. We've really seen an uptick in state agency audits, especially the past few months. I'm located here in Charlotte, and so frequently we've had clients lately with audits in Florida, North Carolina, and South Carolina. Of course, it's not an exhaustive list, but it's states that do require the use of E-Verify in some capacity. And so these audits are sometimes easier to respond to in some ways because they are generally more focused on E-Verify records. And so aside from the government shutdown, it's relatively easy to pull those E-Verify reports, although there can be some work on the back end if you have employees in many different locations. They're also a little bit easier to respond to in that you get slightly longer to respond generally. Of course, you'll want to read any notice that you get carefully, but think something more like 30 days versus the 3 days you get in a federal audit. But I don't want to lose sight of the fact that you all may be getting state inspections as well. Okay. So let's go through what happens in when you get a federal notice of inspection. That's what kicks off the federal audit. As I said, typically you only get 3 business days to respond and to produce documents. You do not want to waive that 3 days if you're asked by ICE to do so. And this is another reason why it's really important to notify counsel immediately. With only 3 days to respond, you want to have counsel engaged early to try to negotiate that response time, to open a dialogue with the inspector, which can include often an initial conversation just to nail down the scope of the audit, what they're looking for. If it's not clear, you also want to make sure you have an understanding about what the desired format is. Of course, that's good to know on the front end so that you're not spending a lot of time collecting materials in a format that's not preferred. You really want to try to give them what they want in the way that they want it. In any case, you want to make sure that you keep copies of whatever it is that you're producing, whether paper copies or electronic copies. The 3-day minimum response time is also very important because you'll want to do a review of the documents that you're going to need to produce prior to producing them. So in a case like this, we recommend performing a self-audit before you produce any of those records for whatever the population is that you're asked for. We recommend correcting any errors consistent with DHS guidance on making those corrections. It'll be really important to make sure that you have a Form I-9 for everyone, that all the sections are complete. And if you don't, this will be the time that you want to go ahead and get those I-9s or make those corrections for anybody who maybe has slipped through the cracks. Throughout this process, you also are going to want to think about what communications you are going to make to your employees about what's happening. Of course, the approach is going to differ depending on the makeup of your workforce and what industry you're in, but we do recommend some standardized communications to employees, though what that looks like might differ. Okay, and then once you compile the documents, whatever you're asked to produce, we also recommend offering to deliver those documents to ICE HSI to alleviate the need for agents to come on site and poke around. And I think something that's really good to note, if you do the work on the front end, having organized and error-free I-9 forms may limit the likelihood that an agency comes back. Obviously not a guarantee, but to limit errors on the front end can be helpful down the road. Okay, so let's talk about the three kind of buckets of the types of errors or issues that may be found in an audit. The first, and there's also USCIS or ICE, one of the two has a nice flow chart on their website. It didn't fit nicely on a slide, but that's also a good resource for you. But the first potential issue is potential work authorization issues that are discovered in an audit based on HSI's review of the documents provided. So in a federal audit, those issues could lead to one of two notices that are variations on the same theme. So the first is the notice of discrepancies, and that's when HSI cannot determine the employee's eligibility to work in the U.S. based on what was provided. You can think of this more like an informational problem about what's in the Form I-9 versus the notice of suspect documents, which is more about the documents themselves. It notifies the employer that the documents either do not relate to the employee or are otherwise not valid for employment authorization. So this notice also outlines the criminal and civil penalties for continuing to employ unauthorized workers. So I do want to say there are times, it may be rare, but where you receive a notice like this and the notice is actually wrong in some regard and the employee is actually lawfully authorized to work in the U.S. I've had a few occasions where HSI was wrong for whatever reason and the employee was able to provide sufficient documents to prove their authorization. So I think the moral of that story is employers who are getting one of these two notices, you need to give the employee an opportunity to provide other or additional documentation to establish a valid U.S. work authorization. And so once you get that, you can give it to HSI who will review it and let you know what the outcome is. And then if it's still not sufficient, employers cannot continue to employ any employee who's on this list, one of the two lists. The second bucket is if there are substantive violations. And if you don't do it every day, you might not know what a substantive versus technical is. That could be a whole other presentation. A substantive violation is going to be something like it's completed untimely, it's not signed by the employee or the employer, something like that. When you have substantive violations, you may get a warning notice. I've had that happen in prior administrations, not so much in this one, or you may receive a notice of intent to fine. So with the warning notice, one thing to say, obviously, it's nice to get that and not be fined, but it could lead to later reinspection to make sure that the employer is in compliance. And we'll go through the notice of intent to fine a little more in a second. For procedural or technical failures, it can be treated in a couple different ways. The first thing you'll get is a notice of procedural or technical failure, and the employer has 10 days to correct those. If you have questions about the differences, please reach out to me. But once you have those outlined in the notice, you have 10 days to correct them. If they are timely corrected, then you're in compliance. If they're not timely corrected, then it kind of turns into a substantive violation, and we go through one of the two options above. Of course, the fourth thing that's not on this list is you have an audit and your Form I-9s are perfect, which is the dream. There are no errors. You get a notice of inspection results, also called a compliance letter, and you're all set. Okay. So Igor mentioned a little bit about the penalties for noncompliance. This slide outlines the various fines that can be assessed. One thing it's important to say at the outset is that while generally you're looking at civil monetary penalties, during an audit, especially one where there are many errors and issues that can be found, that can be a precursor to an additional enforcement action. So just another plug for getting counsel involved early in these. On the left side of the slide are the penalties for Form I-9 paperwork violations. Igor mentioned at the beginning that these have increased for 2025, and that's because these are adjusted annually for inflation. So each year in the Federal Register, there's going to be a notice outlining what the new fines are for the coming year, and those listed here are the ones for 2025, which are anywhere from $288 to $2,861 per violation. You can see how it could add up quickly for larger employers. There's also a possibility of upward or downward adjustment based on the 5 factors that I have listed here. We talk a lot with our clients about the good faith of the employer. So this is one of the reasons why it's so important to have a robust compliance program and to perform self-audits, which we'll talk about in a little bit, because all of those things can help to mitigate fines if errors are found. On the right side of the slide are potential fines for knowingly employing unauthorized workers. Knowingly can be actual or constructive knowledge. And so the constructive knowledge piece is where things can get tricky because it's really fact dependent. So if you have a question about a particular employee or situation, please reach out to us. We'd be happy to help you navigate that. And then this is more Mindy's realm, but in more egregious situations, there can be criminal penalties if there's been a pattern or practice of knowingly hiring unauthorized workers. And then, of course, penalties for other related crimes like trafficking or harboring. Okay, like I said before, at least in prior administrations, I have seen warning notices issued with no intent to fine. But the other option is to get the notice of intent to fine from ICE. If the notice of intent to fine is served, the employer is entitled to a hearing. And you must request that hearing typically within 30 days. If there's no timely request, ICE will issue a final order based on, whatever was in the notice. There's also the option of negotiating a settlement with ICE. And so to do that, the employer has to request the hearing and then engage with ICE to come to a resolution. If there is no settlement in that case, then ICE will go on to file a complaint and the hearing will move forward to determine the employer's liability. As I alluded to a little bit, it's important for employers to work proactively to put themselves in the best possible position if immigration agents show up at your organization. And so Igor is going to take you through some of the different ways that employers can do that.
So Katie did the scary part of telling you all about the different inspections and the different potential fines and even the potentiality for criminal actions. But the good news is with proactive I-9 compliance, you can mitigate a lot of the scary things that Katie just talked about. And I do want to reiterate that even though the E-Verify system is currently down, you still have to properly complete the Form I-9 within the first 3 days of an employee's start date. Just because the E-Verify system is down, that doesn't mean your I-9 obligations all of a sudden goes away. So keep doing the I-9s for new employees just as you have been doing. The government shutdown does not change that. So, what does a proactive I-9 compliance program look like? Well, the ultimate goal is that if you do get a notice of inspection, your I-9s are kept neat and orderly, and they are complete, and they can be produced quickly and easily. And once they are reviewed, the technical and substantive violations are minimal, if not non-existent. So what does that look like, right? Well, first of all, you've got to have a system for keeping the Form I-9s easily accessible, separate from the personnel file. And as far as storing I-9s, employers can use a paper system, they can use an electronic system, or they can use a combination of both. A lot of companies in the last few years went from paper I-9s to electronic I-9s for new hires. And so for the ones that were in paper prior to the system switch, you can keep those in paper as long as they are well maintained and well organized. And then for new hires that complete an electronic Form I-9, you just want to make sure that you've got an electronic I-9 storage system that meets the USCIS requirements for integrity, accuracy, and accessibility. The key to an electronic storage system is that you've got to ensure that it can prevent unauthorized changes. You've got to ensure that you can easily retrieve legible copies. And you've got to make sure that the system can maintain an audit trail of any changes or alterations to the I-9 and a detailed index of that for immediate retrieval should you have to respond to a notice of inspection. The other part of a robust I-9 compliance program is periodic training to individuals who are tasked with the Form I-9 and E-Verify completion and compliance. About a year ago, the Form I-9 itself changed. There was a new form that came out. And so it was important to update the individuals that complete the I-9s to use the new form. But you want to keep periodic training to make sure that those muscles are still working properly, and to make sure that the employees who handle these documents and who handle E-Verify are up to date on the latest and greatest developments. And then finally, and this is a very big and very pressing topic right now, and that's keeping up to date with work authorization changes. As I'm sure you've seen in the news, there's been a lot of litigation about temporary protected status for several countries and parole status. And so one of the big aims of the Trump administration and DHS Secretary Kristi Noem was to remove temporary protected status from individuals from certain countries. And corresponding to that was the removal of their employment authorization document, meaning that once their parole status was revoked, they were no longer authorized to work in the United States. And so their status went from being able to work here to not being able to work here. And so in June of this year, DHS came out with something they called the Status Change Report. And this was a new thing, and it allowed E-Verify employers to review their aggregate E-Verify case data for any employees who presented an employment authorization document for employment verification, which has now been revoked by DHS. And when you go on the E-Verify website, which unfortunately you cannot do right now, but when you can again, and you can pull this report, it contains the document revocation date, it contains the case number, and it contains the A number for each affected case or each affected employee. And so when you can pull that information, the recommendation from DHS is to use the Form I-9 supplement to immediately begin the re-verification process for each current employee whose employment authorization document appears on that status change report. So in a lot of instances, someone might have gotten work authorization through parole status, and you'll see a C11 designation on their employment authorization document. In the meantime, they applied for and obtained some other, work authorization status. Their I-9 didn't have to get re-verified at the time because their original work authorization hadn't expired. And so their name would then appear on this status change report. But when you go to re-verify this employee, they'll have the updated work authorization documents that give them a status separate and apart from the status that was revoked. Now, that will be the case for some employees that you try to re-verify. but that will not be the case for all employees that you may have to re-verify. And so again, that's why it's important to check that E-Verify status change report. What we found through experience with clients is that some have very, very good initial I-9 processes and programs and training, but they are less so on the re-verification piece. And sometimes you'll have folks whose employment authorization documents have expired, who were not timely re-verified or re-verified at all. So it's important to keep up with expiring employment authorization documents as well as employment authorization documents that are being revoked by the Department of Homeland Security. To that same end, as I said, there's been a lot of litigation, a lot in the news about temporary protected status. The USCIS temporary protected status website does have regular updates about the various things that are going on. And so in addition to checking the E-Verify status change report, we recommend checking the USCIS temporary protected status website on a regular basis. And finally, because these things tend to move fairly quickly, we also recommend setting up a news alert for immigration updates. McGuireWoods regularly puts out immigration updates for its clients on new activity that is happening, and it's a good way to have at least somebody that is up to date on what is going on in the immigration world. So that is our that is not our last slide. As Katie mentioned, engaging in regular self-audits is a good mitigating measure because you can figure out what's missing or what's wrong and what needs to be fixed, and you can correct technical mistakes in accordance with DHS guidance. So things to consider are timing, whether you want to do so on a regular basis or ahead of a possible merger or an acquisition where I-9s are going to be reviewed as part of the due diligence process, or if you have a reason to believe that an audit is forthcoming. You don't have to go company-wide. You can sort of limit audits to what you think is best under the circumstances. But the key is you want to avoid the appearance of a discriminatory or a retaliatory audit. Immigration status is a protected category. And so you don't want to design an audit that at least has the appearance of targeting a certain immigration or non-immigration status. And again, Katie does a lot of this, and she's great at it. She's very good at both the I-9 compliance training and the assistance with conducting actual I-9 audits. So if needed, reach out to counsel. So again, the benefits of regular self-audits are pretty clear. If you don't know what's wrong, you can't fix it. And if you can't fix what's wrong, you're certainly going to be caught off guard by an inspection. But if you do know what's wrong, in a lot of instances, you can fix it. And if there is an inspection, well, lo and behold, you've prepared for one and done all that you could to mitigate any adverse effects. And quite frankly, at the end of the day, for legal departments, HR professionals, and operations, if you've done the proactive measures, that certainly gets rid of some of the stress, knowing that you've done everything that you can do to prepare. So again, we're going to follow the words of the great Coach Lombardi, failing to prepare is preparing to fail. But on our end, good preparation is the key to success. I know there's been a good number of questions in the chat box. Mindy, Katie, and I will get a list of those questions, and we're going to reach out to you all individually to make sure that you get your question answered and to also make sure that we can address with you directly anything else that you may have questions about. So we're going to end here. Here's some nice pictures of myself, Mindy, and Katie. And so finally, I want to say thank you very much for taking time out of your busy schedules to come listen to us. And I hope you all have a great rest of the day and a great rest of the week. Thank you very much.